Hello and welcome to the Lincoln Journey. Today is part 15 of the Conspirators, the story of the Lincoln assassination. The most important decision made about the trial of the conspirators was considered a foregone conclusion in the minds of those who made the decision. The American system of jurisprudence, with its deep antecedents in English common law, with blind justice weighing all the evidence fairly and impartially, was given the heave-ho, and the trial was held by military commission. The most important opinion on the matter was that of Secretary of War Edwin Stanton, who was running the investigation and, it has been argued, running the country during this time. Stanton's intention was clear from the wanted poster that he himself had composed and promulgated on April 20th, which warned that all persons assisting Booth, Harold, or John Surratt shall be subject to trial before a military commission and the punishment of death. Accounts vary on how closely he stage-managed the whole proceeding, but Stanton either personally made or strongly influenced such decisions as who would be charged, how they would be tried, who the judges would be, and that the trial would be held in secret. Stanton's titular boss, President Andrew Johnson, sanctified these decisions in his order of May 1st. Johnson had been president for all of 15 days, and while he and Stanton would, in time, become such bitter enemies that Johnson would be impeached for trying to fire Stanton, at this point, the accidental president had yet to orient himself well enough to act independently of his Secretary of War. To Stanton, trial by military commission was a no-brainer. Thousands of military commissions had held court during the Civil War on cases great and small. Still, it was controversial, especially considering the decision to close the doors. As the New York Evening Post said, "The government is making a prodigious and fearful mistake in the mode of trial it has adopted for the conspirators in the late assassination. It makes a double blunder, in fact, first in resorting to a military tribunal, and secondly, in causing the proceedings to be held in secret. The civil law is everywhere in the ascendant, and the ordinary courts are competent to any criminal inquest or decision." The government would shortly admit the error of holding the proceeding in secret, but it would remain unrepentant of employing the military commission. Eventually, however, the concept would be tested in court in a famous, though somewhat less dramatic case. In parte Milligan, the Supreme Court ruled against using military commissions when, as the Post said, the civil law is in the ascendant. Should we pause in our story to examine the ironies of parte Milligan as they relate to the Lincoln assassination trial? No? Well, this is something I worked on before, so I think we should. This ought to be fun for one of us at least. The case involved Lambdin Milligan, an Indiana lawyer who was implicated in a plot to overthrow the state governments of Indiana, Ohio, and Michigan by freeing and arming Confederate prisoners of war using weapons stolen from federal arsenals. See, John Wilkes Booth didn't have the only plot to free Confederate prisoners. Milligan and 3 others were arrested in October of 1864 and tried by a military commission. All were found guilty and 3 were sentenced to hang. Milligan hired a new lawyer, prominent Democrat Joseph McDonald, who, as Indiana Attorney General, had known Attorney Lincoln in the 1850s. McDonald journeyed to Washington to plead for clemency for Milligan after his January 1865 sentencing. He found Lincoln in what he described as a singularly cheerful and reminiscent frame of mind, and he was surprised that his interview lasted from early evening until 11:00 p.m. Falling back upon his old lawyer days, Lincoln, recalled McDonald, went over the history of my client's crime as shown by the papers in the case, and suggested certain errors and imperfections in the record. With a nudge and a wink, Lincoln said that the papers would have to be corrected, and that he had hopes that by the time that was accomplished, the war would be over, and we shall none of us want any more killing done. Meanwhile, Lincoln wasn't ready to release Milligan and his accomplices. "I'll keep them in prison a while to keep them from killing the government," Lincoln quipped. Pretty funny, huh? Well, no one was laughing when John Wilkes Booth killed the government's chief executive 4 months later. When the corrected papers returned to the White House in May, Lincoln's successor, Andrew Johnson, was president, and although the war was over, he was in no mood to grant pardons. He said the 3 Indianans would be executed on May 19th. But by now, leaders in both political parties were calling for executive clemency, and Johnson also received a letter calling for a review of the case in federal court from the U.S. District Court judge in Indiana and the Supreme Court justice in charge of the federal circuit there, Judge David Davis. On May 17th, Johnson commuted the sentences to life imprisonment. David Davis used to be a state circuit court judge in Illinois. For 3 months each spring and 3 more each fall, a traveling court would visit county seats too small or unorganized to support a full legal apparatus. Lincoln was one of many lawyers who got clients by writing Davis's 8th Judicial Circuit, but he was the only one, other than the state's attorney, who typically stayed on the road with the judge the full 6 months in the Illinois 8th. He and Judge Davis became close friends, Davis delighting in Lincoln's endless stock of humorous stories, and in time trusting Lincoln enough to allow the popular attorney to take Davis's place on the bench during his temporary absences. When Lincoln ran for president in 1860, Davis managed his unlikely victory at the Republican National Convention in Chicago. Davis's reward was a Supreme Court appointment in 1862. When Lincoln died of his gunshot wound, his son Robert begged Davis to serve as executor to his father's estate, saying that Davis was the only person he could trust in the position. Davis and the Indiana judge reviewed Milligan's petition for a writ of habeas corpus and felt that the issue needed a definitive ruling by the Supreme Court. They issued a certificate of division, saying they couldn't agree on the matter. They really did agree, but this would allow the case to be heard in Washington. The case came up in March of 1866, a year after the war ended and Lincoln was assassinated, and some of the biggest names of the American bar took part, including future President James Garfield. Milligan's team accepted his guilt. Their argument was that the Constitution guaranteed him a trial by a civilian jury. Congress gave Lincoln statutory authority to suspend the habeas writ in a bill passed in 1863. However, that same law said that prisoners held under this authority must be indicted by a grand jury or set free. Milligan's attorneys also argued that the Constitution's requirement for suspending habeas corpus, that there be a threat to public safety, was not met, as the Indiana conspiracy was far from the battle lines. The court ruled in ex parte Milligan to set Milligan and his Confederates at liberty, and Davis was given the duty of writing the majority opinion. He didn't dispute the president's authority to suspend the privilege of the writ, but he said that the Constitution gave no authority for military courts except in extreme circumstances, when martial law is required to preserve the safety of the army and society. Otherwise, the civil authority, with its protection against arbitrary measures, and which was operating unimpeded in Indiana, must prevail. It was well recognized that this was an easier decision to reach now that the war was over. As Davis put it in his opinion, during the late wicked rebellion, the temper of the times did not allow that calmness and deliberation and discussion so necessary to a correct conclusion of a purely judicial question. But Davis must have felt a pang over criticizing the measures taken by his longtime friend. Elsewhere, he separates Lincoln from those who would abuse presidential power. He wrote, "Wicked men, ambitious of power, with hatred of liberty and contempt of law, may fill the place once occupied by Washington and Lincoln. And if this right is conceded and the calamities of war again befall us, the dangers to human liberty are frightful to contemplate. He also wrote a friend, "I am fully satisfied that Lincoln was opposed to these military commissions, especially in the northern states, where everything was open and free." This may have put Davis's mind at ease, but it overlooks Lincoln's own words in his 1862 executive suspension of the habeas writ, which states that throughout the entire country, not just war zones, those involved in disloyal acts, quote, "shall be subject to martial law and liable to trial by punishment by courts martial or military commission," unquote. Furthermore, Lincoln clearly didn't object to Milligan's imprisonment. While alive, Lincoln wielded enormous, unprecedented presidential power, justifying it as necessary to save the nation. He endured scathing criticism for his actions. His death silenced his enemies, but one of his friends struck down as gently as he could one of Lincoln's most controversial measures. But the High Court's ex parte Milligan ruling came far too late to benefit the conspirators in the cells of the old penitentiary. And it isn't hard to imagine that if the case on the docket had been about a presidential assassination, the justices may have rendered a decision in favor of military commissions. As long as we're idly speculating, let's say that Seward had died and Lincoln had lived. Would Lincoln have approved of a military commission to try the conspirators? Would he have compared this situation to Lambdin Milligan's and found a commission to be justifiable? Or would he have reasoned that, the war being over, the civil authorities should again prevail? I believe it would have been the latter. But it's time to get back to what really happened. On May 8, 1865, the panel of judges was called to order by its president, Major General David Hunter. The 9 commissioners were all U.S. Army generals or colonels. Judge Advocate General Joseph Holt led a team of 3 prosecutors. He also acted as legal advisor to the judges. Nothing unusual about this for a military commission, but an obvious departure from the standard of fairness in a civil trial. General Holt had served with Edwin Stanton in the cabinet of President James Buchanan, Lincoln's immediate predecessor, in the last days of Buchanan's administration. They had become good friends and close colleagues, and Holt worked directly with President Lincoln during the war in reviewing decisions of military courts. When Holt advised the commission that the trial ought to be held in secret to protect witnesses from retaliation, Stanton's hand was seen in the decision. On May 10th, after the defendants' hoods were removed, the charges against them were read out. It was alleged that, incited and encouraged by President Jefferson Davis and other Confederate officials, the defendants conspired unlawfully, maliciously, and traitorously to kill and murder Abraham Lincoln, Andrew Johnson, William H. Seward, and Ulysses S. Grant. They were asked if they objected to any of the judges and told they could retain counsel. Oh, the hoods? They were worn by all the prisoners except Mary Surratt and Dr. Samuel Mudd. Lewis Powell, while still on the Saugus, attempted suicide by bashing his head against a bulkhead on April 22nd, his 21st birthday. Possibly inspired by this, 2 days later, Secretary Stanton requested that the prisoners aboard the ironclads shall have for better security against conversation a canvas bag put over the head of each and tied around the neck with a hole for proper breathing and eating but not seeing. The torture of wearing the bags is better imagined than described. Just think about when the Center for Disease Control told you not to touch your face. Especially considering that the hands of the prisoners were secured by devices called Lilly irons, designed for dangerous or self-destructive mentally ill patients. They kept the wearer's hands separated and immobile. So how did they feed themselves? The breathing hole in the hood didn't line up well with the mouth, and the prisoner could hardly align the hole with one hand while feeding himself with the other. In his memoir, Sam Arnold said, "It being with the greatest difficulty and frequently impossible to place food in my mouth, a sentinel kindly volunteered his service to perform that office for me." Michael Kaufman says that Ned Spangler's guards did the same. quote, in violation of their orders, unquote. Commissioner Cyrus Comstock, who didn't want to sit on the commission anyway, was appalled at this treatment, as were others, and eventually the canvas hoods were dispensed with. Arnold says that the hoods, which caused his face to be swollen, bloated, and soiled, were never removed except in the presence of court officials from on or about April 25th until June 10th, 46 days. The short time allowed to engage a lawyer, along with the reluctance of many attorneys to try such a case, especially in front of a military tribunal, along with the fact that some of the lawyers requested were considered too pro-Southern to be allowed, made a further farce of the proceedings. Some of the defendants found competent, if ill-prepared, counsel. Some had to make do with lawyers who were inexperienced and in over their heads. Others couldn't find anyone at all in the few days allowed them, and in the end had to share with their fellows. Mary Surratt briefly had the services of Reverdy Johnson, a U.S. Senator from Maryland and former Attorney General who was legendary for his prowess as a cross-examiner. He focused not on Surratt's guilt or innocence, but rather the legality of the trial. He said the defendants weren't soldiers, Washington was safe from military attack, and its courts operated without hindrance, so a military commission was inappropriate. After a commissioner objected to Johnson's participation due to his opposition in 1864 to Maryland voters having to take a loyalty oath, Johnson stated that he was as anxious as anyone to see justice done on those guilty of assassinating the president. And while he would do whatever the evidence will justify me in doing in protecting this lady, he would not protect anyone whom, when the evidence is offered, I shall deem to have been guilty, even her. However, perhaps in the end, doubting Surratt's innocence, Johnson soon withdrew as counsel. General Grant testified on May 12th. Disturbed that the proceedings were closed to the public, he and General Comstock went directly to President Johnson to complain. Johnson would say neither yea nor nay, but the next day Judge Holt said that the most sensitive testimony was finished and the courtroom doors would henceforth be open. By the way, Comstock got his wish and was removed, ostensibly because he was on the staff of General Grant, who was supposed to be one of the intended victims, but really because he was telling people that the case should be tried by a civilian court. As these kinks were being worked out, Jefferson Davis, a fugitive since the fall of Richmond on April 3rd, was captured on May 10th in southern Georgia. Although Judge Advocate General Holt steadfastly maintained that Davis and his government were involved in the conspiracy, Davis was imprisoned at Fortress Monroe in Virginia and never charged in the case. Eventually indicted for treason, Davis spent 2 years at Fortress Monroe but never stood trial. Holt appears to have accepted or even encouraged perjured testimony linking the defendants to the Confederacy, but no convincing evidence ever arose. The trial continued from May 8th until June 30th. When I first wrote this, I thought the best way to keep the trial summary from being drawn out interminably was to individually examine the fates of the 8 defendants. I'm not sure it worked out like I imagined, but we will go forward with the best intentions and recount the trial as it proceeded for Samuel Arnold, George Atzerodt, David Harold, Dr. Samuel Mudd, Michael O'Loughlin, Lewis Powell, Edman Spangler, and the Surratt that didn't get away, Mary Surratt, in that order. Then we will examine the further adventures of the Surratt that got away, John Surratt. Then we will make some valedictory remarks and put a stop to this business. See you next time for Part 16.